Hey guys, welcome back to our new video. I am teaching you the Customs Act 1962, Act 52 of 1962. The Customs Act has implemented from 1st February 1963. In the year of 1963, this has been implemented, and this was made in the year 1962. But this had been implemented in the year 1963. So guys, I am Mangesh Hande. I am teaching you the Customs Act 1962, Customs Clearance, Import and Export. Now today's time is 6:06 in the morning, and I am shooting this video for you, for giving you the knowledge of the Customs Clearance, Customs Processes, Customs Act. So guys, we had seen some sections from the chapter number 5, Levy of and exemptions from customs duties. We were seeing the sections from 12 to section number 27. So which are these sections? So section number 12 is dutiable goods, section number 13 is duty on pilfer goods, section number 14 is valuation of goods, section number 15 is date for determination of rate of duty and tariff valuation of imported goods. Section number 16 is date for determination of rate of duty and tariff valuation of export goods. Section number 17 is assessment of duty. Section number 18 is provisional assessment of duty. Section number 19 is determination of duty where goods consist of articles liable to different rates of duty. Section number 20 is reimportation of goods produced or manufactured in India. Section number 21 is goods derelict, wreck, etc. Section number 22 is abatement of duty on damaged, deteriorated of goods. Section number 23 is remission of duty on lost, destroyed or abandoned goods. Section number 24 is power to make rules for denaturing or mutilation of goods. Section number 25 is power to grant exemption from duty. Section number 25A, inward processing of goods. Section number 25B, outward processing of goods. Section number 26, refund of export duty in certain cases. Section number 26A, refund of import duty in certain cases. And section number 27 is claim for refund of duty. These all sections I have already explained in my previous videos. Please visit to my channel to watch these sections in detail. So in this video we are going to see the section number 27A, interest on delayed payment of refund. So in the section number 27A, interest on delayed refunds, if any duty ordered to be refunded under subsection 2 of section 27 to an applicant is not refunded within 3 months from the date of receipt of an application under subsection 1 of that section, there shall be paid to that applicant interest at such rate not below 5% and not exceeding 30% per annum, as is for the time being fixed by the central government by notification in the official gazette on such duty from the date immediately after the expiry of 3 months from the date of receipt of such application till the date of refund of such duty. So in the subsection, there is not given subsection, there is given provisions in section number 27A, interest on delayed refunds. If any order is given for refund under subsection 2 of section 27, and to the applicant and refund is not made within 3 months from the date of receipt of the application under subsection 1 of that section, there shall be paid to the interest to the importer or exporter not below 5% and not exceeding 30% as per notification mentioned in the official gazette. Now currently government paying 6% interest rate on delayed payment of refunds. How much? 6% only. And from importer they are taking 15% interest rate. So understand this. If customs have to pay the interest, they will pay only 6%. And if importer or exporter have to pay interest on delayed payment of duty, they have to pay 15% interest rate on that duty. So provision second in the section 27A, interest on delayed refunds, provided that where any duty order to be refunded under subsection 2 of section 27 in respect of an application under subsection 1 of that section made before the date on which the Finance Bill 1995 receives the assent of the President is not refunded within 3 months from such date, there shall be paid to the applicant interest under this section from the date immediately after the 3 months from such date till the date of refund of such duty. Explanation: where any order of refund is made by the Commissioner of Appeals, Appellate Tribunal or National Tax Tribunal or any court against an order of the Assistant Commissioner of Customs or Deputy Commissioner of Customs under subsection 2 of section 27, the order passed by the Commissioner of Appeals, Appellate Tribunal, the National Tax Tribunal or as the case may be by the court shall be deemed to be an order passed under that subsection for the purposes of this section. So in this section there is 2-3 main points, that interest on refund duty is applicable only after 3 months time is over. After 3 months interest will be applicable on refund of duty. So refund order is given under subsection 2 of section 27, and in the subsection 27, in the section 27A, interest on delayed refunds. There is and if there is any cases pending in the Commissioner of Appeals, Appellate Tribunal, National Tax Tribunal, the date of such order or decision will be considered. From that date, the 3 months will be considered, and thereafter the interest will be applicable on refund of duty, if any case is pending in Appellate Tribunal or with Commissioner of Appeals. So this is section 27A, interest on delayed refunds. Section number 27 is of claim for refund of duty, and section 27A is of interest on delayed refunds. How much government is paying interest on the delayed refunds? I already told you that only 6% customs will pay you the rate of interest on the delayed refund of duty. And if importer or exporter has not paid duty on time of any imported or export goods, then the importer or exporter have to pay the rate of interest at the rate 15%. So understand the difference, 6 and 15% here. Now, section number 28. Recover of duty is not levied, not paid, short levied, short paid, or erroneously refunded. Section number 28 is recover of duty is not levied, short paid, short levied, or erroneously refunded. Subsection 1. Where any duty has not been levied or not paid, or has been short levied or short paid or erroneously refunded, or any interest payable has not been paid, part paid, or erroneously refunded for any reason other than the reasons of collision or any willful misstatement or suppression of facts. Clause A. The proper officer shall, within 2 years from the relevant date, serve notice on the person chargeable with the duty or interest which has not been so levied or paid, or which has been short levied or short paid, or to whom the refund has erroneously been made, requiring him to show cause why he should not pay the amount specified in the notice. So, the proper officer within 2 years serve notice to the person chargeable with the duty or interest that why he has not paid the duty or interest till such date. Provided that before issuing notice, the proper officer shall hold pre-notice consultation with the person chargeable with duty or interest in such manner as may be prescribed. So, before issuing such notice, the proper officer shall hold pre-notice consultation with the person chargeable with the duty. So this is here clearly mentioned, and this is mandatory for proper officer. Clause B. The person chargeable with the duty or interest may pay before service of notice under Clause A on the basis of Clause first on his own ascertainment of such duty. Clause second, the duty chargeable, the duty ascertained by the proper officer. And in the clause there is clearly mentioned that person chargeable with the duty or interest may pay before service of the notice under Clause A on the basis of the duty ascertained by his own or the duty ascertained by the proper officer. The amount of duty along with interest payable thereon under section 28 AA, or the amount of interest which has not been paid, so paid or part paid, provided that the proper officer shall not serve any show cause notice where the amount involved is less than rupees 100. So if the amount is less than 100, then proper officer shall not serve the show cause notice to the concerned person chargeable with duty. Subsection 2. The person who has paid the duty along with interest or amount of interest under Clause B of subsection 1 shall inform the proper officer of such payment in writing, who on receipt of such information shall not serve any notice under Clause A of that section in respect of duty or interest so paid or annually, or any penalty leviable under the provisions of this act or the rules made thereunder in respect of such duty or interest. Provided that where notice under Clause A of subsection 1 has been served and the proper officer is of the opinion that the amount of duty along with interest payable under section 28 AA and the amount of interest at the case may be as specified in the notice has been paid in full within 30 days from the date of the receipt of the notice, no penalty shall be levied, and the proceedings against such person or other person to whom the said notice is served under Clause A of subsection 1 shall be deemed to be concluded. Subsection 3. Where the proper officer is of the opinion that the amount paid under the Clause B of subsection 1 falls short of the amount actually payable, then he shall proceed to issue the notice as provided for in clause A of that subsection in respect of such amount which fall short of the amount actually payable in the manner specified under that subsection, and a period of 2 years shall be computed from the date of receipt of information under subsection 2. Subsection 4. Where any duty has not been levied or not paid, or has been short levied or short paid, or erroneously refunded, or interest payable has not been paid, part paid, or erroneously refunded by reason of clause A collusion, clause B any willful misstatement, clause C suppression of facts by the importer or the exporter or the agent or the employee of the importer or exporter, the proper official shall within 5 years from the relevant date serve notice to the person chargeable with duty or interest which has not been so levied or not paid, or which has been so short levied or short paid, or to whom the refund has erroneously been made, requiring him to show cause why he should not pay the amount specified in the notice. Subsection 5. Where any duty has not been levied or not paid, has been short levied or short paid, or the interest has been short or the interest has not been charged or has been short paid, or the duty or interest has been erroneously refunded by reason of a collusion or willful misstatement or suppression of facts by the importer or the exporter or the agent or the employee of the importer or the exporter, to whom a notice has been served under subsection 4 by the proper officer, such person may pay the duty in full or in part as may be accepted by him, and the interest payable thereon under section 28AA, and the penalty equal to 15% of the duty specified in the notice, or the duty so accepted by that person within 30 days of the receipt of the notice, and inform the proper officer of such payment in writing. So in the subsection 5, if any officer issue notice under subsection 4 to the concerned person of duty payable, then he should have to pay the duty within 30 days and with 15% interest, and inform the same to the proper officer in the writing. Subsection 6. Where the importer or exporter or the agent or the employee of the importer or the exporter, as the case may be, has paid duty with interest and penalty under subsection 5, the proper officer shall determine the amount of duty or interest and determination if the proper officer is of the opinion, clause first, that the duty with interest and penalty has been paid in full, then the proceedings in respect of such person or other persons to whom the notice is employed under subsection 1 or subsection 4 shall without prejudice to the provisions of sections 135, 135A, 140 to be deemed to be conclusive as to the matter stated therein. If a person who served notice under subsection 1 and subsection 4 has paid the duty and interest with fine and penalty as prescribed, then the same notice should be concluded. Clause 2, the duty with interest and penalty has been paid falls short of the amount actually payable, then the proper officer shall proceed to issue the notice as provided for in clause A of subsection 1 in respect of such amount which falls short of the amount actually payable in the manner specified under that subsection, and the period of 2 years shall be computed from the date of receipt of information under subsection 5. Subsection 7. In computing the period of 2 years referred to in clause A of subsection 1 or 5 years referred to in subsection 4, the period during which there was any stay by an order of a court or tribunal in respect of payment of such duty or interest shall be excluded. Subsection 7a. Save as otherwise provided in clause A of subsection 1 or subsection 4, the proper officer may issue a supplementary notice under such circumstances and in such manner as may be prescribed, and the provisions of this section shall apply to such supplementary notice as if it was issued under the said subsection 1 and subsection 4. Subsection 8. The proper officer shall, after allowing the concerned person on an opportunity of being heard and after considering the representation, if any, made by such person, determine the amount of duty or interest due from such person not being in excess of the amount specified in the notice. Subsection 9. The proper officer shall determine the amount of duty or interest under subsection 8. Clause A. Within 6 months from the date of notice in respect of case falling under clause A of subsection 1. Clause B. Within 1 year from the date of notice in respect of cases falling under subsection 4 of section 28. Provided that where the proper officer fails to so determine within the specified period, any officer senior in rank to the proper officer may, having regard to the circumstances under which the proper officer was prevented from determining the amount of duty or interest under subsection 8, extend the period specified in clause A to a further period of 6 months and the period specified in clause B to a further period of 1 year. Provided further that where the proper officer fails to determine within such extended period, such proceedings shall be deemed to have been concluded if no notice had been issued. Subsection 9. And notwithstanding anything contained in subsection 9, where the proper officer is unable to determine the amount of duty or interest under subsection 8 for the reasons that clause A, an appeal in a similar matter of the same person or any other person is pending before the appellate tribunal or the High Court or the Supreme Court. Clause B, an interim order of stay has been issued by the appellate tribunal or the High Court or the Supreme Court. Clause C, the board has in a similar matter issued specific direction or order to keep such a matter pending. Or Clause D, the settlement commission has admitted an application made by the person concerned. The proper officer shall inform the person concerned the reason for non-determination of amount of duty or interest under subsection 8, and in such case the time specified in subsection 9 shall not apply from the date of the notice but from the date when such reason ceases to exist. Subsection 10. Where an order determining the duty is passed by the proper officer under this section, the person liable to pay the said duty shall pay the amount so determined along with the interest due on such amount, whether or not the amount of interest is specified separately. Subsection 10a. Notwithstanding contained in this act, where an order for refund under subsection 2 of section 27 is modified in an appeal and the amount of refund so determined is less than the amount refunded under said subsection, the excess amount so refunded shall be recovered along with interest thereon at the rate fixed by the central government under section 28AA. from the date of refund up to the date of recovery as a sum due to the government. Subsection 10b. A notice issued under subsection 4 shall be deemed to have been issued under subsection 1 if such notice demanding duty is held not sustainable in any proceedings under this act, including at any stage of appeal, for the reason that the charges of collusion or any willful misstatements or suppression of facts or to evade duty has not been established against the person to whom such notice was issued, and the amount of duty and the interest thereon shall be computed accordingly. Subsection 11. Notwithstanding anything to the contrary contained in any judgment, decree or order of any court of law, tribunal or other authority, all persons appointed as officers of customs under subsection 1 of section 4 before the 6th day of July 2011 shall be deemed to have and always had the power of assessment under section 17 and shall be deemed to have been or always had been the proper officers for the purposes of this section. Explanation. For the purposes of this section, relevant date means clause A, in a case where duty is not levied or not paid or short levied or short paid or interest is not charged, the date on which the proper officer makes an order for the clearance of goods. Clause B, in a case where duty is provisionally assessed under section 18, the date of adjustment of duty after final assessment thereof or reassessment as the case may be. Clause C, in a case where the duty or interest has been erroneously refunded, the date of refund. Clause D, in any other case, the date of payment of duty or interest. So guys, we have seen section number 28, recover of duty is not levied, short paid, short levied or erroneously refunded. So in the next video, we are going to see the section number 28A, 28AA, then section number 28AAA, section 28B, section 28BS, and section 28BB. So till time we have seen up to section number 28 of the chapter number 5, levy of and exemption from customs duty. That's it, guys. Please, if you like my videos, please like, share and subscribe to my channel, and don't forget to forward with your friends who required the knowledge of Customs Act 1962 and customs clearance. Thank you guys for watching my video.